Spring comes slowly to Montgomery, Alabama, but in March of 1960, it arrives not with warmth, but with ink. You are standing in the newsroom of the New York Times on West 43rd Street in Manhattan, where the hum of linotype machines fills the air like distant thunder. The smell of metal and paper and hot lead hangs heavy. Editors move between desks with galley proofs in hand, red pencils tucked behind ears, voices low and urgent. The rhythm of a deadline builds around you, that particular pressure that turns hours into minutes, that makes every word count twice. On March 29, 1960, a full-page advertisement appears in the Times. It is not a news story. It is not an editorial. It is a paid announcement purchased by a group called the Committee to Defend Martin Luther King and the Struggle for Freedom in the South. The headline reads, "Heed their rising voices." You can see it now if you close your eyes. That dense column of text, surrounded by white space, the names of 64 signatories listed at the bottom like a roll call. Entertainers, clergy, labor leaders, Harry Belafonte, Eleanor Roosevelt, Marlon Brando, A.J. Muste. The ad costs $4,800. It will cost far more than that before the story ends. The advertisement describes events unfolding across the South. It speaks of students staging sit-ins at lunch counters, of police confrontations, of arrests and expulsions. It describes a wave of terror aimed at silencing those who would challenge segregation. And it names no one directly, but it describes actions in Montgomery, actions attributed to police, actions that involve Dr. King. L.B. Sullivan reads the ad in his office at City Hall. He is one of 3 elected commissioners in Montgomery. His jurisdiction, public affairs. That includes the police department, the fire department, the city cemetery. He has held this position since 1959. He is a man accustomed to authority, to the rhythms of governance in a southern city where power is neither questioned nor shared lightly. The advertisement does not name him, but he believes it speaks of him nonetheless. You are in that office now, in your mind. The March sun streaming through tall windows, the sounds of downtown Montgomery rising faintly from the street below. Sullivan sits behind a broad desk, reading. The ad describes police ringing the Alabama State College campus. It describes padlocking a dining hall to starve students into submission. It describes truckloads of armed officers. It describes Dr. King being arrested 7 times. Sullivan reads these lines with mounting anger, because he knows, as any official in Montgomery would know, that these details are not entirely accurate. The dining hall was never padlocked. Dr. King was arrested 4 times, not 7. The police did not ring the campus in a siege. The students sang "My Country, 'Tis of Thee" on the state capitol steps, not on campus. These are small errors, shadings, compressions of events across time and place, the kinds of imprecision that sometimes occur when narrative urgency outpaces verification. But to Sullivan, they are not small, they are falsehoods. And because the ad speaks of the police, and because he is the commissioner in charge of police, he believes the ad speaks of him. He believes it accuses him, personally, of orchestrating a campaign of terror against black students and Dr. King. And in Alabama, in 1960, such an accusation is not merely offensive, it is legally actionable. You are watching now as Sullivan begins to move. He does not act alone. He consults attorneys. He reaches out to other officials who feel similarly aggrieved. Governor John Patterson will file his own suit. So will the mayor. So will another city commissioner. But Sullivan is first. On April 19, 1960, less than a month after the ad appears, Sullivan files a libel suit in circuit court in Montgomery County. He names the New York Times as defendant. He names 4 black clergymen whose names appeared among the signatories: Ralph Abernathy, Fred Shuttlesworth, S.S. Say, and J.E. Lowry, though they did not write the ad, did not approve its final text, and may not have known their names would appear. Sullivan asks for $500,000 in damages. $500,000. In 1960, that is not symbolic. That is annihilating. You are holding the complaint now in your mind, the paper crisp and formal, the language precise. It alleges that the advertisement is false and defamatory, that it injured Sullivan's reputation, that it exposed him to public contempt, ridicule, and shame. It does not need to prove that anyone actually thought less of him. It does not need to show that he lost business, lost friends, lost standing. Under Alabama libel law, the injury is presumed. The words themselves are the harm. And because the ad contained errors, because some of the facts were wrong, the question is not whether the Times defamed Sullivan. The question is only how much it will pay. This is not the first such suit. It will not be the last. By the time Sullivan's case reaches trial, 11 libel actions have been filed against the Times in Alabama, seeking a combined total of $5.6 million. Other Southern officials are watching. If Sullivan wins, the message will be clear. Northern newspapers that cover the civil rights movement, that publish criticisms of Southern officials, that allow their pages to carry advertisements supporting desegregation, those newspapers can be sued into bankruptcy, one jurisdiction at a time. You are standing now at a threshold. On one side, the traditional law of libel, which has always held that false statements injuring reputation are not protected speech. On the other, the reality of a press trying to cover a social movement in real time, in hostile territory, under threat of crushing liability for even minor errors. The advertisement was placed. The complaint was filed. The machinery of law begins to turn. Slowly at first, then faster than anyone expected. In New York, the Times receives notice of the suit. The editors confer with the legal department. They review the ad. They see the errors. They know Alabama law. They know what libel is. And they know, with a kind of cold certainty, that under existing law they will lose. The only question is how much the loss will cost, and whether it will be survivable. You can feel the weight of that knowledge settling over the newsroom like dust. This is not abstract. This is not theoretical. This is a bill that will come due, rendered in a courtroom 1,000 miles away, in a county where not a single potential juror is likely to be sympathetic to a northern newspaper or the movement it has dared to document. And so the case begins, not with a question of truth or fairness, but with a question of survival. And with it, a question no one has fully articulated yet, a question that will take 4 years and a journey to the Supreme Court to answer. Can the First Amendment survive in a nation where officials may bankrupt critics by suing them for every error, no matter how small, in every jurisdiction where power is entrenched and dissent is dangerous? The courtroom awaits. The case moves south. You are traveling now, in your mind, down from New York toward the deep south. The train passes through Virginia, through the Carolinas, through Georgia. The landscape outside the window shifts. Red clay, pine forests, small towns where the railroad tracks bisect everything into before and after. You are headed toward Montgomery, a city of 130,000 souls, a city that once served as the first capital of the Confederacy, a city where the bus boycott began 4 years earlier and where the weight of history presses down on every sidewalk, every courthouse step, every word spoken in public. The case is assigned to Circuit Judge Walter B. Jones. You are in his courtroom now. It is a large room, high-ceilinged, with tall windows that let in the Alabama light in long, slanting beams. The benches are wooden, worn smooth by decades of use. The judge's bench sits elevated, imposing. The jury box waits, empty for now, 12 seats that will soon be filled by 12 white men from Montgomery County. There will be no black jurors, not because the law explicitly forbids it, that would be unconstitutional, but because the jury rolls are drawn from voter registration lists and the machinery of disenfranchisement has been thorough. In 1961, fewer than 10% of eligible black citizens in Alabama are registered to vote. In Montgomery County, the percentage is lower still. The odds of a black citizen appearing on a jury in a case like this are not zero, but they are close. The Times is represented by a local attorney, a man navigating waters both legally treacherous and politically fraught. The defendants, the 4 clergymen whose names appeared on the ad, are represented by other counsel. They did not write the ad. They did not pay for it. They have no institutional resources behind them. They are, in many ways, collateral damage in a larger war. The plaintiff, L.B. Sullivan, is represented by a team of experienced litigators. They are confident. They have home field advantage. They have Alabama law on their side. And Alabama libel law is unforgiving. You are reading the statute now, the words clear and cold. In Alabama, a statement is libelous if it tends to injure a person's reputation or expose them to public contempt. Truth is a defense, but the burden is on the defendant to prove every material fact. If the statement contains any false assertion, even a minor one, truth is not a complete defense. The plaintiff does not need to prove malice, does not need to prove injury, does not need to show that anyone actually read the statement and thought less of him. The publication itself, if false and defamatory, is presumed to cause harm. And because Sullivan is a public official, because the ad criticized police actions, Alabama law creates a further presumption that any criticism of government conduct reflects directly on the officials in charge. You can see how the pieces lock into place. The ad described police actions in Montgomery. Sullivan oversees the police. Therefore, the ad was about Sullivan, even though it never named him. The ad contained factual errors. Therefore, it was false. A false statement that injures reputation is libel. Libel is not protected by the First Amendment. The trial begins on November 1st, 1960. You are in the gallery now, watching as the jury is impaneled. 12 men, all white, all local. The voir dire is brief. The questions are routine. No one asks whether the jurors have opinions about the New York Times. No one asks whether they have opinions about the civil rights movement, about the sit-ins, about Dr. King. No one needs to ask. The answers would be obvious. The courtroom fills slowly, reporters, spectators, the idle curious. The air is warm despite the season, heavy with expectation. You can hear the rustle of paper, the creak of wood, the soft murmur of voices before the judge enters. Judge Jones takes the bench. The trial begins. The Times calls its own witnesses. They present evidence that the ad was submitted by a reputable organization, that it was reviewed before publication, that the Times believed it to be substantially accurate. They point out that Sullivan is not named. They argue that the errors are minor, immaterial, that the ad's general thrust is true, that black students and civil rights activists were facing opposition, intimidation, and violence throughout the South. The jury listens. But the law is clear. Substantial truth is not enough. General accuracy is not enough. If any material fact is false, the publication is libelous. And the ad contains false facts. The dining hall was not padlocked. Dr. King was not arrested 7 times. The police did not ring the campus. These are not matters of interpretation, they are errors. And under Alabama law, errors are not protected speech. You are in the courtroom as the judge instructs the jury. His voice is calm, steady, procedural. He explains libel. He explains presumed damages. He explains that because the ad was published, because it contained false statements, because it referred to Sullivan, even without naming him, the only question is how much the Times must pay. He does not mention the First Amendment in his instructions, because under Alabama law, the First Amendment does not protect libel. The jury retires to deliberate. You are waiting now in the stillness that follows. The courtroom empties slowly. Attorneys gather papers. Spectators drift toward the exits. Outside, Montgomery continues its ordinary rhythms. Traffic, commerce, the low hum of a city going about its business. Inside, the clock ticks. The jury is out for 2 hours and 20 minutes. When they return, you are in your seat again, watching as they file in. 12 men, faces composed. They do not look at the defendants. The foreman stands. The verdict is read. The jury finds for the plaintiff, L.B. Sullivan. They award him the full amount requested, $500,000. $500,000. You can feel the air leave the room. It is the largest libel judgment in Alabama history. It is more money than most people in Montgomery will see in a lifetime. It is enough to cripple a newspaper. And there are 10 more cases waiting. If all the plaintiffs win, the Times will owe over $5 million in Alabama alone. That is more than the paper's total assets in the state. It is, in practical terms, an existential threat. The Times immediately announces it will appeal, but the Alabama Supreme Court is not a sympathetic venue. The clergyman defendants appeal as well, but they have fewer resources, less institutional support. They are fighting not just for money, but for the principle that citizens may criticize their government without being crushed by lawsuits filed in jurisdictions designed to punish dissent. The case begins its slow ascent through the appellate system. You are watching it rise now, out of Montgomery, out of the Circuit Court, into the Alabama Supreme Court, and finally, inevitably, toward Washington. Toward 9 justices who will be asked to decide whether the Constitution protects a newspaper that publishes false statements in good faith while covering a social movement that challenges the status quo in regions where legal and political power remain aligned against that movement. The appeal is filed, the briefs are prepared, the arguments are refined, and somewhere in the distance, the Supreme Court waits. You are in Washington now. It is January 6th, 1964, a cold, clear Monday in the Capitol. The Supreme Court building rises before you, white marble columns bright against the winter sky. The words above the entrance, "Equal justice under law," are etched deep, their shadows long in the morning light. You climb the steps slowly, feeling the weight of history in every footfall. Inside, the great hall stretches before you. The ceiling soars overhead. Busts of former Chief Justices stand in silent witness along the walls. The air is hushed, reverent, thick with the accumulated gravity of every case ever argued here. You are walking now toward the courtroom itself, where oral arguments will begin at 10 o'clock. The courtroom is smaller than you imagined, more intimate. Mahogany panels line the walls. Red velvet curtains frame the bench. The ceiling is coffered, adorned with symbols of justice and law. There are seats for approximately 300 spectators. They fill quickly. Attorneys, journalists, scholars, civil rights activists, representatives of the times. Everyone understands what is at stake. The case is New York Times Company versus Sullivan, but it carries the weight of a dozen similar cases, and behind it the shadow of a question that has grown too large to ignore. Can the press function in a democracy if it can be bankrupted by officials it dares to criticize? At precisely 10 o'clock, the marshal's voice rings out. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. You rise. The justices enter through the burgundy curtains behind the bench, taking their seats in order of seniority. Chief Justice Earl Warren sits at the center. To his right, Justice Hugo Black, Justice William O. Douglas. To his left, Justice Tom C. Clark, Justice John Marshall Harlan II. Then Justice William J. Brennan, Jr., Justice Potter Stewart, Justice Byron White, Justice Arthur Goldberg. 9 men, 9 votes, 1 question. The marshal speaks again. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. You sit. The Chief Justice leans forward. We will hear argument in number 39, New York Times Company versus Sullivan. Herbert Wexler rises to argue for the Times. You are watching him now, a man in his mid-50s, a professor at Columbia Law School, one of the most respected constitutional scholars in the country. He wears a dark suit, carries a leather folio. His voice is calm, precise, devoid of theatrics. He does not need to perform, he needs to persuade. He begins by framing the question simply. This case, he says, is about whether the Constitution permits a public official to recover damages for criticism of his official conduct based on common law libel rules that impose liability without fault and without requiring proof of actual harm. Under Alabama law, he explains, the Times was held liable for publishing an advertisement containing minor factual errors, even though the paper believed the ad to be substantially accurate, even though Sullivan was not named, and even though there is no evidence that anyone who read the ad actually thought less of him. The rule in Alabama, Wexler argues, is that any false statement about government conduct is presumed to defame the officials in charge of that conduct, and those officials may collect damages without proving malice, without proving fault, without proving injury. This rule, he says, is incompatible with the First Amendment. Justice Harlan interrupts gently. But counsel, libel has never been considered protected speech. Hasn't this court repeatedly held that libelous utterances are outside the protection of the Constitution? Wexler does not hesitate. Yes, Your Honor, but this court has never defined what libel means in the context of criticism of public officials. And if the definition used in Alabama is allowed to stand, then the practical effect is to create strict liability for any factual error in any publication criticizing government, enforceable by officials in jurisdictions hostile to that criticism. He pauses, lets the point settle. The result would be to chill reporting on matters of urgent public concern. No newspaper can guarantee that every fact in every article or advertisement is flawless. If officials can sue for every error, and if liability is presumed, and if damages are presumed, then the cost of covering controversial issues becomes prohibitive. Justice Black leans forward. His voice is quiet but edged. Are you saying there is an absolute privilege to criticize public officials, even falsely? No, Your Honor, Wexler replies. We are saying that false statements made without knowledge of falsity and without reckless disregard for truth should not be actionable when they concern the official conduct of public officials. The First Amendment requires breathing space for error. Otherwise, the press will engage in self-censorship to avoid lawsuits, and the public will lose access to information it needs. Justice Brennan is listening intently. You can see him taking notes, leaning back slightly, his gaze steady on Wexler. Wexler continues. He walks the court through the facts. The ad described real events, sit-ins, arrests, police presence at demonstrations. The errors were minor. The dining hall was not padlocked, but students were disciplined. Dr. King was arrested 4 times, not 7. The general picture was accurate. The details were flawed. But under Alabama law, those details were enough. Enough to presume defamation, enough to presume harm, enough to award $500,000. If this judgment stands, Wexler says, then every Southern official who feels aggrieved by press coverage of civil rights activities can file suit in a friendly jurisdiction, secure in the knowledge that a local jury will award massive damages for even trivial errors. The cumulative effect will be to silence national media on the most important domestic issue of our time. He does not need to say that some errors are inevitable, that journalism is done in haste, under pressure, in the fog of unfolding events, that perfection is not a realistic standard. The justices already know this. The question is whether the Constitution knows it too. Wexler's time expires. He sits. Now M. Roland Nachman Jr. rises for Sullivan. You are watching him now, a man in his 40s, a skilled litigator from Montgomery, arguing for the preservation of a legal framework that has existed for centuries. He is polite, articulate, confident. He does not need to defend segregation. He does not need to defend Alabama's political system. He only needs to defend the law of libel. And that law, he argues, is ancient, well-established, and necessary. Libel, Nachman begins, has never been protected by the First Amendment. This court has said so repeatedly. False statements that injure reputation are not speech the Constitution values. Alabama law simply enforces this principle. He continues, the ad, he says, was false. It accused the Montgomery police of serious misconduct, ringing a campus, padlocking a dining hall, arresting Dr. King 7 times. These accusations were untrue. Sullivan, as the official in charge of the police, was entitled to defend his reputation. Justice Stewart interjects, but counsel, Mr. Sullivan was not named in the advertisement. How can he claim it defamed him if no one reading it would know it referred to him? Nachman is ready. Your Honor, the ad described actions by the police. Mr. Sullivan supervised the police. Everyone in Montgomery understood that criticism of the police reflected on Mr. Sullivan. Several witnesses testified that they believed the ad referred to him. But those were people who already knew him, Stewart presses. What about the general reader in New York or California? Would they know? The general reader is not the issue, Nachman replies. Libel law has always focused on injury to reputation in the community where the plaintiff is known. Mr. Sullivan's reputation is in Montgomery. That is where the injury occurred. Justice Douglas, who has been silent, speaks. His tone is flat, almost disinterested. So you're saying that any criticism of government published in Alabama can be treated as personal defamation of the officials in charge, even if those officials are not named? If the criticism is false, yes, Your Honor. Even if the publisher believed it to be true? Belief is not a defense to libel, Nachman says. Truth is the defense. If the statement is false, the publisher is liable. Justice Brennan leans forward. But doesn't that impose an impossible burden? How is a newspaper supposed to verify every fact in every article, every advertisement, every letter to the editor, especially when covering fast-moving events in distant locations? Nachman does not flinch. With respect, Your Honor, if a newspaper cannot verify a fact, it should not publish it. Freedom of the press is not a license to defame. You are listening to this exchange with a sense of something tightening. The arguments are civil, the tone is professional, but the gulf between them is vast. Weschler is arguing that democracy requires space for error, that the marketplace of ideas cannot function if every mistake is punishable, that the First Amendment must adapt to the realities of a free press operating in a fractured nation. Nachman is arguing that reputation matters, that individuals have a right to defend themselves against falsehood, that the First Amendment does not protect lies. Both positions are, in their own way, correct, and the court must decide which principle prevails. The arguments conclude. The justices retire to confer. You remain in the courtroom as it empties, the silence settling over the chamber like dust. The case is now in their hands. You are outside now, walking slowly down the steps into the cold January air. The case will not be decided today. It will take months for the court to deliberate, to draft opinions, to work through the implications of whatever rule they choose to announce. But the stakes are clear. If Sullivan's judgment stands, the Southern strategy will succeed. Newspapers covering civil rights will face a barrage of lawsuits in hostile jurisdictions. Juries sympathetic to segregation will impose crippling damages. The practical effect will be to suppress coverage of the movement, not by government censorship, but by private litigation enforced through state courts. If the Times prevails, the court will need to articulate a new rule, a constitutional limit on state libel laws, a framework that balances the press's need for breathing space against the individual's right to reputation. It has never done this before. For 173 years, the court has held that libelous speech is outside the First Amendment's protection. To rule for the Times, the court will need to redefine libel itself, to create a distinction between private libel and public criticism, to say that certain kinds of falsehoods are protected if they are made in good faith about matters of public concern. This is not a small step. This is a recalibration of constitutional law. And so the case waits, the city waits, the press waits, and in Montgomery, 11 other libel suits are pending, waiting to see what the highest court in the land will say. Somewhere in the building behind you, the justices are beginning their work. The case has been argued, the evidence presented, the law articulated. Now comes the silence of deliberation and the long, slow process of finding an answer. The courtroom is empty now, the arguments made. The marble halls await a verdict that will reshape what it means to speak freely in a nation where power and press must somehow coexist. The justices meet in conference 3 days after oral argument. You are not in the room. No one is except the 9 of them. The conference room is closed to clerks, to staff, to history itself until the decision is rendered. But you can imagine it. A long table, high-backed chairs, the Chief Justice at one end. Portraits of former justices watch from the walls. The air is still. The weight of the question hangs over everything. Chief Justice Warren speaks first, as tradition dictates. Then, each justice in order of seniority. They go around the table. They vote. They discuss. The details remain sealed for decades, but the outcome eventually becomes clear. The court is unanimous, or nearly so. They will reverse the Alabama judgment. But the reasoning, the how of it, that is where the real work begins. Justice Brennan is assigned to write the majority opinion. He is 57 years old, a former New Jersey Supreme Court justice, appointed by Eisenhower in 1956. He is known for his careful craftsmanship, his ability to build coalitions, his sensitivity to the practical consequences of legal rules. He understands that this case is not merely about one libel suit in Alabama. It is about the architecture of freedom itself. He returns to his chambers and begins to write. You are there now, in your mind, the office quiet, lined with books, the desk covered in briefs and memos and draft pages. Brennan works methodically. He knows the stakes. He knows that if the court simply reverses on narrow grounds, finding that Sullivan was not actually defamed or that the evidence was insufficient, the problem will recur. Another official will sue. Another jury will award damages. The cycle will continue. The court must announce a rule, a principle, a constitutional standard that will govern all future cases like this one. And that rule must do several things at once. It must protect the press's ability to cover matters of public concern without fear of crippling liability for innocent errors. It must preserve some protection for individual reputation. It must draw a line between public officials and private citizens. It must be grounded in the First Amendment, but also in the realities of how journalism actually works, in haste, under pressure, with imperfect information. Brennan begins with history. You are reading over his shoulder now as the opinion takes shape. He writes of the Sedition Act of 1798, a law that made it a crime to publish false, scandalous, and malicious statements about the government. The act was never tested in the Supreme Court. It expired in 1801. But in the court of history, Brennan writes, it has been thoroughly discredited. The First Amendment, he argues, reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Wide open, uninhibited. These are not words the law of libel has traditionally embraced. You are in the courtroom again. It is a Monday morning. The justices are on the bench. The room is full. The press gallery is packed. Everyone knows this case matters, though few yet understand how profoundly it will reshape American law. Justice Brennan reads the opinion from the bench. His voice is steady, clear, without drama. He summarizes the facts. He explains the Alabama rule. He describes the First Amendment's history and purpose. And then he announces the holding. The rule of law applied by the Alabama courts is constitutionally deficient. The judgment is reversed. You can feel the shift in the room, a collective intake of breath, a leaning forward. Brennan continues. He explains the actual malice standard. He applies it to the facts. The Times, he notes, did not know the ad contained errors. There is no evidence of reckless disregard. The mistakes were the result of the ad sponsors relying on their own knowledge of events, not of deliberate falsehood. Sullivan, therefore, cannot recover, not under the Constitution, not even under state law as newly constrained by federal constitutional requirements. The opinion is unanimous on the judgment. Justice Black, joined by Justice Douglas, writes separately to say he would go further. Justice Goldberg, joined by Justice Douglas, also writes separately to emphasize the importance of the decision. But the core holding is uncontested. Public officials may not use libel law to punish criticism of their official conduct unless they can prove the critic lied knowingly or recklessly. This is the rule. This is now the law of the land. You are watching the justices leave the bench now, disappearing behind the curtains, leaving the courtroom to absorb what has just occurred. Reporters rush for the exits. Typewriters will clatter. Telephones will ring. By evening, the decision will be front-page news across the country. In Montgomery, L.B. Sullivan learns that his victory has been overturned. The $500,000 judgment is gone. The 11 other pending libel suits filed by Alabama officials will likely fail under the new standard. The strategy of using libel law to suppress coverage of the civil rights movement has been dismantled, not by politics, not by protest, but by the Constitution itself. In New York, the Times receives the news with quiet relief. The paper will not be bankrupted. The precedent will protect future reporting. The press, for the first time in American history, has explicit constitutional protection for good faith errors in reporting on public officials. But the decision is more than a victory for one newspaper. It is a redefinition of the relationship between citizens and government. It enshrines in constitutional law the principle that democracy requires space for imperfect speech, for angry speech, for speech that makes mistakes in the service of holding power accountable. You are thinking now of all the words that have been written about this case in the decades since. Scholars call it one of the most important First Amendment decisions ever rendered. It is cited thousands of times. It spawns an entire body of law governing defamation, public figures, matters of public concern. It changes journalism. It changes politics. It changes what it means to criticize those in power. But on this day, in this moment, it is simply a decision. 9 justices, 1 opinion, a rule that says the press may make mistakes so long as it does not lie. The courtroom empties slowly. You remain seated, watching the last spectators file out. The marble walls hold no opinion of their own. They have witnessed thousands of arguments, thousands of decisions. They will witness thousands more. But this one, this case born from an advertisement, from a lawsuit filed in anger, from a confrontation between a Southern official and a Northern newspaper, this one will endure. Not because it was perfect, but because it understood something essential, that freedom of speech is not freedom to be right. It is freedom to be wrong, loudly and publicly, in the service of seeking truth. And in a democracy, that freedom is not negotiable, even when it costs $500,000, even when it overturns a century of common law, even when it protects those who make mistakes, especially then. You stand, you walk toward the exit. The decision has been announced, but its consequences have only just begun. The opinion is 42 pages long. You are reading it now, not in the courtroom, but afterward, in the quiet of a library or a study, turning pages slowly, feeling the architecture of the argument unfold. Justice Brennan's prose is methodical, almost mathematical. He builds the case step by step. He begins with first principles. The First Amendment embodies a profound national commitment to uninhibited debate on public issues. He moves through history, the Sedition Act, the evolution of free speech doctrine, the recognition that even false statements have value in the marketplace of ideas because they force truth to sharpen itself in response. He addresses the Alabama rule directly. Under that rule, criticism of government is chilled not by direct censorship, but by the threat of ruinous lawsuits. The effect is the same: self-censorship, silence. The public loses access to information. Officials escape accountability. This, Brennan writes, is incompatible with the First Amendment. And so he crafts the actual malice standard. It is not, he is careful to note, the same as common law malice, ill will or spite. Actual malice in this context means a specific state of mind, knowledge of falsity or reckless disregard for truth. It is a subjective standard focused on what the publisher knew or should have known at the time of publication. It is a high bar, deliberately so, because the point is not to make it easy for officials to sue. The point is to make it nearly impossible, unless they can prove that the press lied knowingly or recklessly. You are tracing the logic now, feeling how each piece connects. The rule protects good faith errors. It protects negligence. It even protects some degree of carelessness. What it does not protect is deliberate falsehood or reckless indifference to truth. And this, Brennan argues, is the right balance. It gives the press the breathing space it needs. It preserves a remedy for actual lies. It places the burden on the public official, not the publisher, to prove fault. The implications ripple outward. You can see them spreading across the legal landscape like cracks in ice. The decision applies not just to newspapers, but to all media. Not just to traditional journalism, but to advertisements, broadcasts, pamphlets, any form of public expression. The definition of public official will need to be worked out in future cases. Does it include appointed officials, employees, candidates for office? But the principle is clear. Those who wield government power must accept greater scrutiny and less legal protection against criticism than ordinary citizens. This is the price of public service. This is the bargain democracy demands. You are thinking now about the concurrences. Justice Black writes separately, as he often does, to argue for an absolute rule. He would hold that the First Amendment completely bars public officials from recovering damages for criticism of their official conduct, true or false. An unconditional right to say what one pleases about public affairs, he writes, is what I consider to be the minimum guarantee of the First Amendment. Justice Douglas joins Black. Together they represent the absolutist position, that debate on public issues should be utterly unrestrained, that even knowing lies should be protected if they concern government and officials, that the marketplace of ideas must be allowed to function without any legal penalties for falsehood. The majority does not go this far. Brennan's actual malice standard preserves some remedy for lies, but the practical difference is small. Proving actual malice is extraordinarily difficult. The standard requires clear and convincing evidence, a higher burden than the usual preponderance standard in civil cases. It requires proof of subjective intent or recklessness, which is hard to demonstrate without access to the publisher's internal thought process. In practice, public officials will almost never win libel suits under this rule, and that is the point. You close the opinion and sit in silence. The words are there, fixed on the page, but their meaning will evolve. Lawyers will cite this case. Courts will interpret it. Future justices will expand it, refine it, occasionally try to limit it. The rule will be extended to public figures, celebrities, prominent individuals who thrust themselves into public controversy, even though they are not government officials. The definition of reckless disregard will be tested, challenged, debated in thousands of cases, but the core holding will remain. You cannot silence criticism of government by suing critics for their mistakes. Not anymore. Not in America. You are outside now, walking through the streets of Washington. The day is bright, cold, clear. People pass by, tourists, bureaucrats, attorneys heading to meetings. None of them know that a few blocks away, in a marble building, 9 justices have just rewritten the rules of public discourse. But they will feel it, slowly at first, then unmistakably. News organizations will become bolder. Investigative journalism will expand. Reporters will dig into government misconduct with less fear of retaliation through lawsuits. The civil rights movement will receive broader, more aggressive coverage. Officials will complain, will accuse the press of bias and recklessness, will call for reforms to libel law. The complaints will continue for decades, but the rule will hold. Because it is not merely a legal doctrine, it is a recognition of something deeper, that democracy is messy, that freedom is risky, that the alternative to tolerating error is to empower government to define truth. And that is a power no government should have. You think of L.B. Sullivan now, back in Montgomery. The case will follow him for the rest of his life. He will be remembered not for his years of public service, not for whatever good or ill he accomplished as a city commissioner, but as the plaintiff in a landmark case that bears his name. He did not choose this role. He filed a lawsuit he believed was justified under the law as it existed. He won at trial. He won on appeal in Alabama. He did everything the legal system allowed him to do. And the Supreme Court said the system was wrong. You think of the 4 clergymen whose names appeared on the advertisement, who were sued as co-defendants, who had no institutional backing, no resources, who faced the same $500,000 judgment and had no way to pay it. The decision frees them too. They were collateral damage in a larger conflict, and the Constitution, belatedly, offers them protection. You think of the New York Times, an institution that will outlive everyone involved in this case, that will continue to publish, to make mistakes, to anger officials, to serve as a forum for debate and criticism and uncomfortable truths. And you think of the thousands of journalists, editors, publishers, bloggers, citizens who will invoke this case in the years to come, who will rely on it when they are threatened with lawsuits, who will cite it as proof that the First Amendment means something real, something enforceable, something that constrains power and protects dissent. The case is decided, but the work it enables has only just begun. You return to the steps of the court. The building stands as it always has, massive and impassive. The words above the entrance, "Equal justice under law," catch the afternoon light. Justice is not always equal. Courts make mistakes. The law evolves. What seemed settled becomes unsettled. What seemed impossible becomes law. But today, in this moment, the court has said something important. It has said that criticism matters more than reputation, that truth matters more than comfort, that democracy matters more than order, and that the price of freedom is tolerating those who get it wrong while trying to get it right. The shadows lengthen. The day ends. The case passes into history, and the First Amendment, quietly and irrevocably, grows stronger. The decision becomes law on March 9, 1964, but its effects unfold over years, decades, generations. You are standing now at a distance, looking back across time, watching the ripples spread outward from this single case. The actual malice standard becomes the foundational rule governing defamation of public officials and public figures. It is cited in tens of thousands of cases. It is taught in every law school. It is invoked in every newsroom facing a libel threat. The civil rights movement continues. The coverage becomes more aggressive. Reporters travel south with less fear that Southern officials will bankrupt their employers through friendly juries and hostile libel laws. The Times publishes more, investigates more, challenges more. Other newspapers follow. Television networks expand their reporting. The machinery of accountability begins to turn. In 1971, The Times publishes the Pentagon Papers, classified documents revealing government deception about the Vietnam War. The government seeks an injunction. The case reaches the Supreme Court in days. The court sides with the press, citing the principles established in New York Times versus Sullivan, that prior restraint on publication is almost never justified, that the press must be free to inform the public about government conduct, even when that conduct is controversial or embarrassing. In 1974, reporters Bob Woodward and Carl Bernstein published their investigations into Watergate. Their sources are anonymous. Their facts are sometimes incomplete, but they are protected by the knowledge that public officials cannot silence them through libel suits unless actual malice can be proven. President Nixon resigns. The system works, in part, because the press is free to do its job. Over the following decades, the rule is tested, challenged, refined. Courts extend actual malice protection to public figures, not just officials, but anyone who voluntarily enters public controversy or achieves widespread fame. The reasoning is similar. Those who seek public attention must accept public scrutiny. Courts struggle with borderline cases. Is a private person who becomes newsworthy still a private person? What about someone who is famous but did not seek fame? What about statements that are opinion rather than fact? The doctrine grows complex, layered, sometimes contradictory, but the core principle endures. You are reading now from a later case, a dissent written by Justice Byron White in 1974. He argues that New York Times versus Sullivan has gone too far, that it overprotects the press at the expense of individual reputation, that the actual malice standard is too difficult to meet and encourages irresponsible journalism. The public interest in being fully informed about public officials and public affairs, White writes, is better served by accurate reporting than by reckless or negligent reporting protected by the actual malice standard. He has a point. The rule does protect some falsehoods. It does make it nearly impossible for public officials to vindicate their reputations. It does create asymmetry. Officials must tolerate criticism that would be actionable if directed at private citizens. But the majority view, consistently reaffirmed, is that this asymmetry is necessary, that the alternative, allowing officials to punish critics, is worse, that democracy depends on the press having the courage to publish, and that courage requires protection from the threat of ruinous lawsuits. The debate continues. It will never be fully resolved, because both sides are defending real values, reputation and truth, individual dignity, and public accountability. The law has chosen which value takes precedence when they conflict, and that choice is embodied in the actual malice rule. You are in a newsroom now, decades after the decision. It could be any newsroom, print, broadcast, digital. The technology has changed, the pace has accelerated, but the fundamental question remains the same. Can we publish this? An editor reviews a story about a government official accused of misconduct. The reporter has sources, documents, but some facts are uncertain. Some sources are anonymous. The official denies everything, threatens to sue. The editor asks the question that always must be asked. Do we know this is false? The reporter says no. They believe it's true. They've checked it as thoroughly as time allows. The editor nods. Then we're covered. New York Times versus Sullivan. The story runs. Maybe it's accurate. Maybe there are errors. Maybe the official is wronged. Maybe the public is served. The system is not perfect. It protects some falsehoods. It tolerates some injustice. but it also prevents a worse injustice: the silencing of inconvenient truths by those in power. You think of the advertisement that started all this. Heed their rising voices. A full page in the Times, purchased for $4,800, containing minor errors about events in Montgomery, signed by 64 people who wanted to support Dr. King and the struggle for civil rights. None of them could have known that this ad would become the foundation of modern First Amendment law, that it would be cited in thousands of cases, that it would protect generations of journalists, activists, critics, and ordinary citizens who dared to speak about those in power. L.B. Sullivan wanted $500,000. He wanted vindication. He wanted to silence criticism. Instead, he gave the nation a precedent that ensures criticism can never be silenced by lawsuit, so long as it is not a knowing lie. There is irony in that. Perhaps tragedy, from Sullivan's perspective. He was a casualty of history, a man whose legitimate grievance under the law as it existed became the vehicle for transforming that law into something he never intended. The four clergymen, Abernathy, Shuttlesworth, C., Lowry, faded from the headlines after the decision. They continued their work. The movement continued. And the case that bore Sullivan's name became synonymous not with his victory, but with his defeat, not with silencing dissent, but with protecting it. You are walking now through the National Archives, past the glass case that holds the original Constitution. You stop at the First Amendment. Congress shall make no law abridging the freedom of speech or of the press. 45 words. Ratified in 1791, litigated ever since. For 173 years, those words did not clearly protect criticism of public officials from libel suits. State courts applied common law rules that dated to English precedent. Reputation was sacred. Falsity was unprotected. The press operated at risk. And then, in 1964, the Supreme Court said, "This is not enough. The First Amendment demands more. It demands space for error. It demands protection for good faith mistakes. It demands that officials accept criticism, even harsh criticism, even unfair criticism, as the price of wielding power in a democracy." The words on the parchment did not change, but their meaning did. You step outside into the present day. The world has changed in countless ways since 1964. The Civil Rights Movement achieved legislative victories. The Civil Rights Act of 1964, the Voting Rights Act of 1965. Segregation ended, legally, if not always in practice. The South transformed. Montgomery transformed. But some things remain constant. Officials still dislike criticism. The press still makes mistakes. Libel suits are still filed. The actual malice standard is still invoked, still tested, still debated. And democracy still depends on the willingness of ordinary people to speak uncomfortable truths to powerful institutions, knowing that the law will protect them if they act in good faith, even if they get some facts wrong. This is not a perfect system, but it is the system the Constitution requires. And it began with an advertisement, a lawsuit, and a question that seemed simple but turned out to be anything but. Can you sue a newspaper for printing something false about you? The answer is yes, but only if you can prove the newspaper knew it was false or recklessly ignored the truth. That qualification changes everything. You return one last time to the Supreme Court steps. The building is quiet now. Evening has come. The tourists have left. The arguments are done. The marble glows faintly in the dusk. Somewhere inside, in the archives, the briefs and transcripts from New York Times versus Sullivan rest in storage. The voices of the attorneys are preserved only in written words. The justices who decided the case are gone. L.B. Sullivan is gone. The clergymen are gone, but the rule remains: actual malice. Two words that protect a nation's right to argue, to criticize, to challenge, to make mistakes in the pursuit of truth. Two words that stand between democracy and silence. You descend the steps slowly. The case is over. The law is settled. The archive is complete. But the work continues. Every day, somewhere, a journalist publishes a story about a public official. Every day, somewhere, an official considers suing. And every day, the shadow of this case, this lawsuit filed in anger in Montgomery, Alabama, this case argued in Washington, this opinion written by 9 justices in 1964, stands as a barrier between power and the press. Not an absolute barrier, not a perfect one, but a barrier nonetheless. And in a democracy, that barrier is not a luxury, it is a necessity. The stars emerge overhead, the city lights glow. You walk into the evening, carrying with you the knowledge of what this case means, what it protects, what it costs. Freedom is expensive. It tolerates error. It creates asymmetry. It frustrates officials and empowers critics, and sometimes gets things wrong. But the alternative is silence. And silence, the court decided, is not what the First Amendment demands. Not in 1964. Not ever. The case is closed. The archive is preserved. And the voices rise still, protected by a rule that says, you may criticize power, even imperfectly, and the law will not punish you for honest mistakes. Heed their rising voices. The words from the advertisement echo across the years, and the Constitution, finally, heeds them.